Mr. Patrick Tay.
Mr. Deputy Speaker, sir, I rise in support of the bill. The update and simplification of the means criteria for legal aid to align them with means criteria used in current social support schemes has been long awaited. The current means test criteria, which takes into account the applicant's disposable income and disposable capital, has been in place since 1958. To apply for legal aid today, applicants have to furnish documentary proof of their disposable income and disposable capital as part of the legal aid application. Even with such stringent means test criteria, there has consistently been a high percentage of applications at around 90% which pass the preliminary means test for legal aid over the past 5 years. The incidence of abuse is low, and the large majority of applicants meet qualifying criteria. In 2016, 57% of the legal aid applicants had only secondary educational qualifications or lower. The challenges that this group face in assessing justice are multifold. First, with lower educational levels, they will meet with more challenges in understanding their legal rights, seeking available recourse, and comprehending legal processes. Second, with limited financial means, there are significant financial challenges in seeking legal recourse. Third, the inability or difficulty faced in seeking legal recourse can exacerbate existing challenges in their lives due to higher levels of stress arising from the inability to resolve the legal issue at hand. Over the past 5 years, about 50% of applicants sought legal aid for matrimonial cases, 10% for monetary claims, and 7% for probate matters. When divorce is on the cards, there would inevitably be strain in the household. The parties involved and their family and children bear the emotional cost of the dragging out of a failing relationship. The ability to seek legal recourse, especially in cases where violence is perpetuated, must be available in the legal system and accessible. There must also be urgency in helping lower-income claimants recover monies owing to them, and assistance for lower-income families who have lost a loved one to unlock assets of the deceased, especially where the deceased was the breadwinner. While the public trustee administers estates of deceased persons where the value of the estate does not exceed $50,000, the public trustee is unable to administer the estate where the deceased was the sole lessee of a HDB flat and the child is eligible to inherit the whole or part of the flat. The mission of the Legal Aid Bureau is about advancing access to justice, the rule of law, the economy and society through policy, law and services. The amendments proposed under this bill indeed further this mission. It is also timely at this juncture to consider a more integrated approach to provide more holistic support to families who are in need. Legal issues are not merely disputes between litigant and defendant. They can be extenuating and longer-term impact on the family. To help families to manage stress arising from the legal dispute and any potential fallout, they can be directed to counselling support. Households in need can be directed to social assistance schemes and employment facilitation services. At the close of the claim, a review should also be conducted to educate vulnerable claimants on how to better protect their legal rights in future. With this, I support the bill. Thank you.